Good afternoon. My name is Professor James Leffler. I want to welcome you back to the conference, How the Law Treats Hate, Anti-Semitism, and Anti-Discrimination, Reconsidered. If you've been with us today, you've known that we have worked through electrical storms to engage some key questions about the nature of anti-Semitism and how lawyers have thought about it, past and present, the history of how it's been addressed in the United States, and the questions of Jewish identity, groupness, and the legal frameworks that Jews have encountered and worked through to try and address discrimination that they and others confront. So we finish our day with a very exciting closing session. And to do so, we want to turn outwards to the pulse of the moment and many of the issues as they're live inside the courts, particularly the Supreme Court, that many of us think about and hear about and want to know where we are and what is going on. So it's my pleasure at this point to introduce the two speakers who will be discussing it in a public conversation for this closing session. This whole event is a co-production of the Religion, Race, and Democracy Lab at the University of Virginia and the Jewish Studies Program at the University of Virginia. And our third partner is the Karsh Center for Law and Democracy at the UVA Law School. Its director, Micah Schwartzman, is the Harvey Cross Dillard Professor of Law, and Martha Lubin Karsh and Bruce A. Karsh Bicentennial Professor of Law at the University of Virginia Law School. And he will be speaking together with Dahlia Lithwick, who is, as you will know, a renowned legal correspondent and commentator and journalist with Slate.com. And what we've asked them to come together to do today is to reflect on some of the immediate questions and recent history of how the court has addressed discrimination, the First Amendment, many of the cases that have dramatically changed some of the legal landscape of the United States, and which Jews are confronted, as are others, with new opportunities and challenges. I want to just alert everyone that the way we're running this in terms of the housekeeping is that I'm going to encourage you to participate by sending through questions, and you can use the Q&A feature to do that. And that will allow you to push questions through as well as to vote them up. So if you see something that you would love to have addressed, that's what we're doing. We've disabled the chat and the raise hand functions just to focus on the exchange that you'll hear, but to allow people to feed their thoughts and questions into it. Today's speakers have a tight time frame and a lot to discuss, but we will do our best to try and get some of your queries also into the mix. And with that, I want to invite into the conversation Professor Schwartzman and Ms. Lithwick. Hi there. Now that you're both there, my role is really to get things rolling as a moderator, and I'd like to turn to Micah and ask you just to frame for us. We've heard a lot of talk today about the presidential executive order, about legislation on the state level, about historical issues of civil rights and discrimination, but there's a lot that has happened recently, right, involving religion, discrimination, and the First Amendment that is key to this picture we're trying to draw of where we are in this moment. So I'll ask you to sort of lay the land out for us a little bit.
Thanks, Jim. And I just want to say on behalf of the Karsh Center that we're so happy to be participating in this program, which has, I think, been wonderful to listen to throughout the day. Let me answer your question by saying that the Supreme Court has been very busy in the context of making decisions under the First Amendment's religion clauses, rendering decisions involving church and state. Over the past few years, we've seen more decisions, more action in this context than we have in many, many years prior to. There were more than a half dozen cases under consideration. Last term, we got 3 important decisions from the court, any of which could have been blockbusters in other terms. To get them all at once, it can feel a little bit overwhelming. But let me start by drawing a couple distinctions. And we're getting decisions from the court in roughly 3 areas. So not this past term, but the year before, we had a decision in a case called American Legion, which involved the Bladensburg Cross, a 40-foot tall cross that you might have noticed if you live around Maryland or Washington, D.C. There was an establishment clause challenge brought to say that the state can't sponsor a cross like this, that it's an endorsement of Christianity in violation of the First Amendment's establishment clause. And the Supreme Court, in a 7-2 decision, affirmed the state's sponsorship of that cross as a war memorial, giving wide latitude, I think, to the state, at least with respect to historical monuments, to authorize state religious symbols. Another set of cases involved state funding of religion. And this term, we had a really important case called Espinoza, which came out of the state of Montana, involving a school finance program, the tax credit, in which the state had tried to exclude religious schools from receiving funding. The state in Montana relied on a state constitutional provision. Many states have constitutional provisions that restrict funding to religious institutions. The Supreme Court said that it violated the free exercise rights of religious individuals to exclude religious schools from receiving funds. We had two other, there's a lot. We had two other really important decisions from the last term involving religious accommodations. So if you're keeping track, we've got a decision 2 terms ago on state support of religious symbols, this term on state funding of religious institutions, and now the question, to what extent does the state have to exempt religious people who object to complying with federal or state laws in various ways? So the 2 big cases here are Little Sisters of the Poor, which involves the coverage of contraception. And this is sort of a tail end of the Hobby Lobby litigation. But again, a 7-2 decision, Justice Kagan, Justice Breyer joining a conservative majority here, as they did in the Cross case. So a little puzzling. We have 2 Jewish justices joining conservatives on the court and wondering what's going on here, and Justice Sotomayor, Justice Ginsburg dissenting in what's become a fairly common pattern of 7-2 decisions in the religion context. The last case that's of note from this last term is Our Lady of Guadalupe, involving what's sometimes called the ministerial exception. That is, that churches have an immunity from anti-discrimination law. This case involved school teachers who were hired by religious schools, Catholic schools out in California in the Ninth Circuit. They were fired for various reasons and raised discrimination claims, and their claims were rejected, again on 7-2 grounds, with Justices Kagan and Breyer joining the court's conservative majority for lopsided victories. I think it's fair to say that what we're seeing across the board in these decisions is very strong push toward aggressive religious exemptions for religious institutions, especially those with a conservative religious bent, and a significant weakening of establishment clause protections against state support of religious symbols and state support of funding. Very strong free exercise, very weak establishment.
Thank you so much, Micah. So Dahlia, what's going on? Why are we seeing all of this?
Well, first of all, I want to just say how good it is to be back at UVA. And I also feel that I really have to apologize. It is very befitting this conference that my Zoom has been glitchy today. And so I am both podcasting from and talking to you now from my stacked up Passover dishes in the basement. And I wish I had a fabulous background, but I think if ever your background were to be stacked up Passover dishes, this seems the apt place. I mean, I think that, and I think this goes to the heart of what your last panel talked about, Jim. The court is trying to reconcile 2 trends. One is that the United States is changing and growing, and that civil rights and civil liberties are complicated in ways that they did not used to be. And at the same time, there is a very well organized, robust set of free exercise claims that would have been unheard of, by the way, 10 years ago at the Supreme Court. And so the court is doing this rather amazing thing, which is the court giveth and the court taketh away. And so, you know, what doesn't kind of get clocked when we talked about the fact that Neil Gorsuch himself writes what I think is one of the single most important important guarantees of employment protection for LGBTQ workers in America. There can be no question it's a landmark piece of litigation. But as Micah just pointed out, religious exemptions and the ministerial exemption will actually be used. I don't think there's any dispute, will be used when schools fire gay workers in the future for religious reasons, and then say, like, that's our ministerial exemption. And so I think it's just maybe a useful beginning to the frame of this conversation to say that the court is also trying very hard to both live in a complicated America with lots of clamoring claims for civil rights and civil liberties, and also very, very much hollowing out some of those claims the same way we saw Obergefell in some sense hollowed out by cake bakers making valid religious claims that they could not be conscripted into doing something that violated their religious freedom and religious expression. And I think we're going to really see that tension strikes me as the seminal tension that we are going to see play out in the religious sort of wars at the Supreme Court and the lower courts for the foreseeable future. There will be lots of giving and lots of take a thing away.
So, and let me ask you both then, in light of that, as you've described it, diversity versus the religious freedom development. So where does anti-Semitism fit into it? I'd love to hear you both reflect on, I guess, both the question of where you see the claims and the alliances happening in terms of people who are bringing tests and looking for new ways to make the court address things, as well as the court itself, right? And the Jewish justices who, as Micah pointed out, took positions, some of them that were surprising to many people who would have expected a different action.
I want Micah to speak to. Micah actually has done this phenomenal roundup of justices referencing Jews in doctrine, which I think is eye-opening. And Micah, maybe, I don't know if there's a way to throw it into the chat or something, but so I want you to have a moment to talk about it. But I will say, you know, Micah mentioned that one of the surprising justices is Elena Kagan, who has become, I think, one of the people who really, Micah's word is appeasement. I'll let him explain why that is, but who has pretty single-mindedly sided with the conservative majority in every one of these 7-2 cases. Kagan is there. And I would just say it's interesting because she started her career at the Supreme Court with this blistering dissent in the Town of Greece case, where she, I think, spoke for every Jew who had ever been forced to sit through any supposedly secular, utterly not secular solemnization or, you know, secular prayer. And she really came out guns blazing, talking about what that was like. And I actually think deeply personal terms. So I think for a lot of us, we anticipated she was going to finally give voice, Jim, to some of those concerns, at least that you're speaking about. And certainly the concerns that, you know, arise when you talk about Judeo-Christian values, but only promote half of that. She is not, I think, proven to be anything like that. And Micah can talk about it a little more. But I do think that Jews and Judaism are used in really interesting ways to make claims about not Jews and not Judaism.
Yeah, Micah, please. What's going on?
I think there are a couple of questions here. You know, it's interesting that most of the cases that we're seeing now are not brought by Jews in the way that we did see cases, active litigation, especially in the 50s and 60s, and trying to dismantle blue laws, you know, involving school prayer. You know, there were Jewish groups and Jewish litigators who were very heavily involved in those early cases. I think there are still Jewish groups involved, and you see this kind of there's a sort of polarization even within the Jewish world in terms of filing amicus briefs in these cases. So in Fulton, which has been mentioned in your prior panel, you know, where you have a challenge from Catholic Social Services, coming up to the court, which will be heard just after the election. If you look at the amicus briefs that are filed in the court, you see Jewish groups on both sides. There are Orthodox groups that are lining up with Catholic Social Services, and you see a range of conservative reform reconstructionist groups lining up with the state to protect anti-discrimination laws. There is some division, I think, with respect to exemption cases, accommodations inside the Jewish world, which may have been exacerbated over the last several years. There's a strange pattern emerging with the justices that Dahlia's touched on and we've mentioned in these 7-2 decisions, whether it has to do with government religious speech, government funding of religious organizations, or exemptions. Across all these cases, we see this 7-2 pattern where Justices Kagan and Breyer join the conservative majority, and we sort of want to know what's going on here. And in an article with a scholar named Nelson Tebbe, who's at Cornell, I've argued that Kagan and Breyer might be engaged in what we called an appeasement strategy. Now, appeasement obviously is a loaded term for historical reasons, but we think that it's hard to find another term that describes the dynamic where you've got what seem to be unilateral concessions for trying to keep the peace, but not getting very much in response. The conservative majority is going to do what it's going to do, and it's not obvious that Kagan and Breyer are getting anything in exchange for their votes or in exchange for conceding some of the reasoning in these cases. And the cases are important. One of the cases is Masterpiece Cake Shop, the wedding vendor case, where Justice Kagan and Justice Breyer agree with the court that state officials were hostile to the baker. And that's really surprising, and it's hard to think that, for example, if there had been a Justice Garland and they'd had another vote instead of Justice Gorsuch, that they would have voted in the same way. I really doubt it. Maybe in some of these cases you could think that, but in some of them, it seems like they're joining the conservative majority strategically. And we might worry that that strategy is not a particularly good one. Now, maybe we shouldn't second guess Justice Kagan. She's brilliant and she's in the court and maybe she knows best, but from the outside, those of us who are watching are wondering, is this a good strategy? Is it gonna work? I think that still leaves a question about what's the role of anti-Semitism in all this, but maybe I'll stop and let Dahlia pick up.
Well, I would just say, I think one could, if one wanted to, write volumes about Justice Breyer. And, Micah started with the Cross case, the weird and perplexing Breyer thinking about old crosses bad, new crosses, or old crosses good, new crosses bad. This is not all that easy to differentiate from his 2 Ten Commandment cases where he's like, some 10 Commandments bad, some 10 Commandments good. And I find myself, I said to Micah and Jim right before the panel, I've been trying to construct a unified theory of why Elena Kagan and Stephen Breyer, it's possible it's entirely strategic. In other words, there's an easy psychological answer to this question, which is because they're trying to do deals. But what it is about the way they look at the world that allows them to split off from Sotomayor and Ginsburg in these cases. And I think Breyer really has a kind of very mid-century kind of country clubby view of religion that is, he's not different that much in terms of age from Justice Ginsburg, but his worldview is so uniquely American in the way he thinks about, particularly, I think, these public displays, but also, as Micah notes, across the different religion cases. He's just got a very sort of sweet, civilizing view of all religion that I think is the best I can do to try to understand. I don't want to say it's a San Francisco thing because I'll offend a San Franciscan, but I can't quite ascertain the root of it.
It's interesting because as you're circling around this, what you both described, it's one. From a historical perspective, one could say it's about feeling so comfortable, as you suggested, Dahlia, so secure in Americanness and an older version of Americanness, perhaps, or maybe not an older one, but this, a certain type of American public life that it doesn't seem offensive. Or you could say that it's as I think Micah's suggesting, for reasons that we may not really understand, a capitulation, basically being sort of outmaneuvered by a certain majority framework. Let me shift us. And before I do that, I want to invite people, there's a lot of people listening, please do shoot through questions so that we can bring them into the mix in the Q&A, just type them in. So we can't do this without talking about COVID. COVID's an interesting thing because of some of the free exercise issues that have come up, which have cut in somewhat, well, I won't say anything about how I think they've cut. I'd rather hear how both of you think they've cut in terms of how the court has dealt with them, and then some of the Jewish voices and Jewish symbolism in these things and how it works with claims about religious freedom for Christians. So what is going on with that? Micah, do you want to start?
So we had a lot of litigation starting in March and April, lots of opinions in the lower courts, district court, circuit, or appellate courts. And then over the summer, we had two Supreme Court cases in which the court basically refused to hear decisions from lower courts and left in place social distancing rules. A case out of California went up, and the court responded with some of the justices offering opinions, including unusually Chief Justice Roberts giving an account of why the court shouldn't hear this case. The case was called South Bay. And the chief, in a pretty perfunctory short opinion, said, basically, we don't think there's discrimination happening here, and we're not going to get involved in various local state decisions involving COVID. We're going to leave these social distancing rules in place, and churches that are regulated by them have to follow those regulations. And then in another case called Calvary Chapel, the court was tested again, this case out of Nevada, where you've got casinos that are operating, and the leaders of churches are saying, well, if casinos are open, how come we can't be open? And the conservatives on the court now are nearly apoplectic. I mean, they're really upset. There are a lot of separate dissenting opinions from Kavanaugh, from Gorsuch, from Justice Alito. They want explanations from the court about why there seems to be disparate treatment. Sometimes businesses don't have to follow these rules, but churches do. They think they're being victimized by state officials. I think those decisions effectively put an end to early challenges, but they'll still be litigated until these regulations are lifted. There's a very strong sentiment out there that these social distancing rules infringe on religious liberty, but Chief Justice Roberts is not interested in hearing these cases.
I mean, I would add two things. One is that it's really interesting. We were talking about Fulton, the Philadelphia case, and I think when you read the amicus briefs in Fulton, it's just really fascinating to watch particularly Jewish groups try to locate themselves in this question of, am I being singled out for abuse and discrimination because I can't perform my mission? Or do I identify myself with, the larger secular community that is trying to make sure that there is no discrimination afoot in using government funds to make determinations about foster care? And that same who am I like is very much at work, I think, in these COVID cases. And so it's really easy if you read Justice Alito or Justice Kavanaugh in these cases, just going off. The notion that a church could be compared to a casino is in and of itself a religious affront. And so it's really, you have, I think, in the earlier cases, Micah noted, Chief Justice Roberts makes two very, I think, non-controversial moves. He's not trying to single out churches. He's simply saying, one, churches are not like, stores where you can go in. He kind of likens it to the bucket of things that it's being likened to, and says churches are just not like that. You don't go into a corner store in California and sing for 2.5 hours and leave. You go in and you get your milk and you get your Coke and you leave. And so for him, that's a simple move. It's just it's a category error to say that churches are like corner stores, therefore they're being singled out for abuse. And so I think to me, it dovetails so nicely with the prior panel, Jim, where we're trying to figure out, is there some animus at work here? And there is no question that if you read these dissents, and we can have a conversation about how these cases are not, being briefed properly or argued properly, and they're not, they are really emblematic of what happens when you make decisions at midnight on a Friday. But I think that there is a really good frame for these that is, are churches being singled out, and synagogues presumably, for abuse? And is the mere comparator here, which is casinos, the affront, or is there something else? The second move that John Roberts makes, which again should be uncontroversial, is, but science, right? He says, I'm not a doctor, not a public health official, gonna just go with what they're telling me, which is that, churches are different. And even that, I think, is experienced as, but how can you apply but science to religious liberty? And so I see these as micro versions of really big thematic confusion around categories and how we think about these, and maybe how Jews locate themselves in those conversations.
Can I add one quick point, which is, if you look at the religion cases that lead up to these two COVID cases from the summer, South Bay and Calvary Chapel, in the last dozen or so cases, religious claimants win all of them, except the travel ban case, right? Except Trump's ban on traveling from Muslim countries. But they win all the other ones, and John Roberts is strongly supportive of religious liberty in all of these other cases. Or at least the conception of religious liberty that's being pressed, especially from the right. And here he meets his limit. And it may just be that he was pushed too far. And with a whole stream of cases that would have followed in the wake of any other decision than the one he made. And with some bad cases, I think, or bad arguments being pushed from earlier decisions where he might have just thought, this is crying wolf, and I don't think there's discrimination here, but it may be that that conservatives pushed too hard, pressed too far in those cases, and he just wasn't willing to go as far as they wanted him to go.
Can I add a note to Micah's note, which is related to absolutely nothing we've just discussed, but worth throwing into the mix here? I think we can't have this conversation without talking about Donald Trump's list of Supreme Court nominees, which is the additional 20 that's added to the 30. This is 4.0, and yay, Paul Clement finally made the list. But I think it's worth saying that in Donald Trump's recitation of what the evils that would befall America if he didn't get to seat, he says he's got 4 seats coming up, and one wonders, maybe Gorsuch needs to be moved along. But I don't know where his 4 seats are, but I do know that his recitation of what he's worried about, someone that was doing signaling in the White House about, and clearly this is all about John Roberts, right? That's why Josh Hawley is on the list. That's why Naomi Rowe is not on the list. But it is really interesting that the thing that he cites in his list of American carnage that is going to come if he doesn't get to fix the Supreme Court is the Pledge of Allegiance, that under God comes out. And I thought that was a really, again, one doesn't want to read too much into whoever's writing his speeches, but the idea that under God, in the midst of the religious sort of warfare that Micah laid out at the beginning, that the pledge is emblematic of something, I thought was really, really interesting, and really removed it from kind of the last few terms and put it in a really different kind of world.
So tell me, you mentioned a couple times the question of who's making these arguments and whether they're ill-advised and ill-conceived and poorly argued. A lot of people who are listening to both of you lay out for us so cleanly these issues, wonder where, quote unquote, the Jews are on this, right? And it's we've seen throughout the day, we talked about it, Jews are split, right? And Jews have multiple opinions about these things, and no one speaks for the Jews. But I want to ask you both to demystify a little bit for us, because I think for many who are listening to this conversation, they wonder actually who tries to speak for the Jews, right? When it comes to amicus briefs, we know there's this long history of Jewish organizations involved, but we know also there seem to be other actors popping up on the scene, and different legal entrepreneurs. So what is that looking like today? Is the landscape just chaotic and diverse about who is petitioning the court and getting involved? Are there still familiar faces? They're just, as Dahlia mentioned to us, kind of confused about exactly where they should fit themselves in. What does it look like with Jews in the court?
Dahlia, you want to go first, or
Jewish organizations, I should say. Yeah.
No, I mean, I would simply say that it's, and I think Micah said this maps really well onto the amicus briefs in Fulton. I think Jews are on both sides. Jews are on, I think there is no doubt, and Micah can talk more about this, a very well organized, very focused, and I would say probably asymmetrically focused Orthodox Jewish community that is weighing in these cases and aligning itself overwhelmingly with kind of conservative Christian groups. And then there are, the conservative movement and the reform movement are, sort of on the team of the ADL, and they're on the team of the liberal, whatever that means, arguments. But I think it's been really interesting to see the same kind of fissure that you see when the Baptist groups who are very, very opposed to what Micah described in Espinoza, very, very vocal, that sort of splinter off from Catholic groups or evangelical groups. I think maybe the beauty of having, my God, a third of the court is Jews. It would have been 4 if Merrick Garland had been seated. And that's unprecedented. Describing, which is, how come they're not doing all the same thing? Like, what happened? Right. There used to be one Jewish seat for a very long time, and you knew what that Jew was going to do. And maybe it's kind of an embarrassment of riches that we have so many Jews that they don't all do the same thing. And by the same token, I think Jews are so powerful in the amicus industrial complex that they are on both sides.
Well, I would say if you read the amicus briefs, you might think that there are as many Orthodox Jews as there are Reform and Reconstructionist and conservative Jews in this country. And although the Orthodox movement may be growing, it's not the case, right? I mean, in terms of just sheer population, the amicus briefs don't reflect the size of the community and the way that it's split proportionally. There's a significant representation on the Orthodox side from the Orthodox Union, from the National Jewish Commission of Law and Public Affairs, COLPA, which has a long history of filing amicus briefs in the court, Agudat Israel on one side, and some other Jewish organizations and some new ones that have come in over the last several years. And on the other side, you have the CCAR and the URJ and National Council of Jewish Women, the United Synagogue of Conservative Judaism, and other groups. I'm just describing the landscape in Fulton, but I think it characterizes the exemption cases more generally. The other thing to say here is and this has been true for a long time, there's a difference within the Jewish world on whether the state should support Jewish institutions with money, with funding through vouchers or through other kinds of programs. And here I'll just say that debate at the level of the court is mostly over. And even at the practical level of Jewish institutions receiving funds, I think under COVID, we've seen a major shift, right? The CARES Act in response to COVID included a lot of money for nonprofits, including religious organizations, and hundreds and hundreds of Jewish organizations throughout the country received an enormous amount of money over the last 6 months under that program. And there was some debate, not only within Jewish groups, but others too, about whether it was appropriate for the state to fund those groups. But that debate was short and really not that controversial, and it's over, and the money went out and it's been received. And I don't think we've fully appreciated the collapse of separation of church and state with respect to funding. Maybe not with respect to some other issues, but at least with respect to funding. We live in a different world than we did a year ago in terms of state funding of religious organizations. And that will be true going forward. It's facilitated by the Supreme Court's decisions in cases like Espinoza, but the federal government has driven a huge truck down that lane, and to the tune of billions upon billions of dollars. And you know, I think in the mid-20th century, there was sort of a settlement on the liberal side of Judaism. You know, going to send our kids to public schools. We're not going to have day schools. We're opposed to public funding of religion. We're separationists. Jews were the most separationist of the separationists when it came to church and state. And the ground has shifted. And I don't know that liberal Jews have quite caught up to what's happened, either in the court or in terms of the structure of government funding.
Can I just one tiny coda to that, or at least to I think the first thing that Micah said, which is, it's really important to realize the asymmetry at work here, because I think if you did read amicus briefs, you would believe that 95% of American Jews are Orthodox. And by the same token, I think you would believe that 95% of America's Christians are Catholics or evangelicals. Like, I think there is a real, it goes to, what's kind of known by the pollsters as the enthusiasm gap around the court, and just the ways in which Orthodox religionists, regardless of the religion, have absolutely settled upon the Supreme Court as the issue. And that is not the case for secular Americans or for sort of religious Americans of any sort of, I don't know what to call it, that isn't Orthodox. But I do think that some of what, Micah was describing in that enthusiasm gap, and even I think in the sort of how did we get here when COVID happened, is simply that Orthodox religionists have very, very much prioritized making change by way of the courts in ways that I think, non-religious Americans have not. And it explains in part why Donald Trump has a list and Joe Biden does not have a list. It explains why, days of the RNC went to the court, and I think 4 minutes of the DNC, maybe 2 minutes, went to the court. I mean, I just think there's an asymmetry around organizing around the courts that maps both onto party and onto religious enthusiasm. Enthusiasm's not the correct word.
It's interesting to think about this in light of what you said at the beginning of our conversation, Dahlia, about court giveth, court taketh, amidst this moment of what everyone understands as change, right? So do you think the motivation, enthusiasm there is because these are groups who think they are going to be outnumbered, in a few years' time, and they want to solidify their position and hold on? Or do you think it's groups that are emboldened by all the changes and saying, no, we've realized this is a strategy for us. We can get what we want. Is it, we began by talking about emotions. Is it, as some people have said, fear and anxiety driving this, or is it confidence? As people have talked about Orthodox Jewish lawyering, they've said, well, there's also an assertiveness that comes with we can make these claims too. They like us, and we can make these claims, and why not play big ball? What do you think when you read through the lines of how people are framing their arguments? Do you see? Can you characterize that as an orientation towards the future?
I think it's yes and yes. I think it's both, Jim. I know that's the most Jewish answer I can give, but I think it's also, it's very much, and you see it again in the amicus briefs, there is a simultaneous framing that is, we are beleaguered victims. We come from a long tradition and a long history. And I loved in the last panel that, you all talked about how history is sort of shot through, these historical arguments are shot through on both sides, right? To say, that we are historically victims, and also we're historically powerful. And I think that those claims rest very easily with being emboldened, with saying we won again. The last ministerial exemption case was 9-0. Let's go for broke this time. And so I think that both of those things can be happening. Maybe Micah has a more sophisticated or nuanced reading, but I think we're very, very good as religious minorities in this country at being simultaneously terrified and simultaneously chutzpahing.
I think that's wonderfully put. I guess I would only say that there's some question about who we're terrified of and who emboldens us. And I think, on the right, you've got groups that are concerned, they have some anxiety about regulation at the local level, maybe even regulation at the federal level, but they're pretty confident about winning in the court. And the court is a place where, as Dahlia said, they can go and expect to be heard and to be successful. And I don't think they've found the outer limits of that yet, and we're in the process of exploring it. They might have hit a wall in the COVID cases, but I suspect in Fulton we're going to see a high watermark in terms of religious exemptions. I mean, at this point, I think we've never seen a court more solicitous of religious accommodations than the current one, and I don't think we're finished there yet.
We're coming to the end here. We just have 2 minutes left, so I want to just ask if either of you has a closing thought, or if you, Naomi Stolzenberg put through 2 important questions. The second one is, will Lemon be overturned? Do you think the Supreme Court will overturn Lemon? Maybe you could take that one in 30 seconds.
And my very quick answer is that, much like Roe, you don't have to write the words "Lemon is overturned" for Lemon to be dead. And I think it is. We have moved on from Lemon, whether or not it's overturned. Maybe Micah thinks different.
Yeah, I mean, on the funding side, I think it's basically a dead letter. The only question left from Lemon, and this is, I think, going to be really hard, is the first part of the Lemon test said that the federal government, or the government, states too, they have to have a secular purpose for their laws. Lemon is a bar toward legislating for religious purposes. And the court's conservatives have long chafed at this. Justice Scalia used to have all kinds of not nice things to say about this aspect of Lemon, but it's been really important, especially in the gay rights cases. Obergefell respects this principle. You don't see religious arguments, for example, opposing gay marriage. The court does not take them into consideration. It is a backbone of religious pluralism and secularism, political secularism in the United States, that our governments don't make decisions on overtly religious grounds. If Lemon goes in that sense, takes that, we'll have, I think, changes that we can't even fully contemplate. I hope that won't be the case. I don't expect it, but as Dahlia said, you don't have to reverse it in name to effectively do away with much of it.
Well, I want to thank you both. We could keep going, but I think we reached a good point and we've reached the end of our time, which is even more important. I want to thank everyone also for joining us to hear Micah Schwartzman and Dahlia Lithwick close out this conference and help us by thinking out loud about where we have been and what is going on and what the broader framework looks like. Our goal has been to bring together people who take different perspectives on how to study these problems. And I want to thank those who've come together to make this happen. That's the Religion Lab here, who is part of a larger initiative at the University of Virginia, the Democracy Initiative, to really try and bring us scholars into deep engagement with current issues in ways that don't simply conscript us to the politics of the moment, but allow us to give perspectives and resources for thinking through these hard questions. I want to thank the law school, and Micah directs the Karsh Center, which is really trying to give informed comment about the rule of law and these issues. And I want to thank colleagues from the program I represent, the Jewish Studies Program, who've, beginning 3 years ago, struggled to figure out what we can contribute to help address anti-Semitism, as well as the other related and larger challenges that all of us face as we think about what law can do to stop hate. Next week, if you want to revisit anything said, this will be up on the website. You can get it through the conference website. More programs related to this, we hope, will be forthcoming. And we really want to thank all of you and wish you a good rest of your day and of your week. Thank you for joining us.